J. Game? Paglaga. Okay, I have 5 items. Okay, Supreme Court, during its session today, acted on the following matters in its agenda, among others. The first, in the matter of GR number 225442, Samahan ng mga Progresibong Kabataan or SPARC et al. Versus Quezon City, represented by its mayor, the City of Manila, represented by its mayor, and Davao City as represented by its mayor. The court, acting on the petition for certiorari and prohibition with an application for injunction and temporary restraining order, challenging the respective curfew ordinances of the 3 local governments as ultra vires for being contrary to RA 9344 or the Juvenile Justice and Welfare Act, issued a temporary restraining order effective immediately and until further orders, enjoining the 3 local government units from implementing and enforcing the so-called curfew ordinances. Respondents' local governments of Quezon City, Manila, and Navotas are directed to comment on the petition within 10 days from notice. Second item, in the matter of GR number 212426, Rene A.V. Sagisag et al. Versus Executive Secretary et al. And GR number 212444, Bagong Alyansang Makabayan, represented by Renato Reyes et al. Versus Secretary of National Defense et al. The court, as per the Chief Justice writing as the ponente and voting 9-4, with Justices Hardeleza and Kagiwan taking no part because of previous participation, as Solicitor General and Chief Presidential Legal Counsel respectively, denied the petitioner's motion for reconsideration filed against its decision of 12 January 2016, sustaining the constitutionality of the Enhanced Defense Cooperation Agreement, EDCA, between the United States and the Philippines. In their motions for reconsideration, the petitioners had argued the court had erred when it ruled that the EDCA was not a treaty and argued that EDCA must be in the form of a treaty in order to comply with the constitutional restriction under Article 18, Section 25 of the 1987 Constitution on foreign military bases, troops, and facilities. Additionally, petitioners reiterated their arguments on the issues of telecommunications, taxation, and nuclear weapons. To this, the court stated that, quote, petitioners do not present new arguments to buttress their claims of error on the part of this court. They have rehashed their prior arguments and made them responsive to the structure of the decision in Sagisag, yet the points being made are the same, unquote. Nonetheless, the court emphasized certain points in its resolution. I have listed them in the summary below. They're a bit long, so you can just take a look at the summary. There are 4 justices who have dissented, the same justices who dissented from the original decision. These would be Justices De Castro, Brion, Bernabe, and Leonen. To my knowledge, all 4 of them are submitting separate dissents to the denial of the motions for reconsideration. Third item. In the matter of GR number 209271, International Service for the Acquisition of Agri-Biotech Applications Incorporated versus Greenpeace Southeast Asia Philippines et al. CropLife Philippines Incorporated, petitioner in intervention, GR number 209276, Environmental Management Bureau et al. Versus Court of Appeals, Greenpeace Southeast Asia et al., CropLife Philippines Incorporated, petitioner in intervention, GR number 209301, University of the Philippines Los Baños Foundation Incorporated versus Greenpeace Southeast Asia Philippines et al., and GR number 209430, University of the Philippines versus Greenpeace Southeast Asia Philippines et al. The court, speaking through Justice Bernabe and voting unanimously with Justice Leonen concurring with a separate opinion, acted on the 9 motions for reconsideration from its December 8, 2015 decision and rendered the following judgment. Quote, wherefore, the motions for reconsideration are granted. The decision dated December 8, 2015 of the court, which affirmed with modification the decision dated May 17, 2013, and the resolution dated September 20, 2013 of the Court of Appeals in CAGRSP number 00013 is hereby set aside for the reasons above explained. a new one is entered dismissing the petition for writ of continuing mandamus and writ of kalikasan with prayer for the issuance of a temporary environmental protection order or TEPO filed by respondents Greenpeace Southeast Asia Philippines, Magsasaka at Scientifico sa Pagpapaunlad ng Agrikultura or Masipag, and others on the ground of mootness. In so holding, the court agreed with the movant's argument that the case should have been dismissed for mootness in view of the completion and termination of the BT Talong field trials and the expiration of the biosafety permits. It also stated that the court should not have resolved the case on its substantive merits due to mootness and should also not have acted on the constitutional question, i.e., whether DAO 08-2002 was unconstitutional, as this matter was only collaterally raised. The court explained that it is not empowered to decide moot questions or abstract propositions or to declare principles or rules of law which cannot affect the result as to the thing in issue in the case before it. Again, there's a summary of what the court said, but let me just state the rationale of the court for its ruling. Quote, all told, with respondents' petition for writ of kalikasan already mooted by the expiration of the biosafety permits and the completion of the field trials subject of these cases, and with none of the exceptions to the mootness principle to properly attend, the court grants the instant motions for reconsideration, hereby dismisses the aforesaid petition. With this pronouncement, no discussion on the substantive merits of the same should be made. Unquote. Item 4, in the matter of GR number 225208, J. Manalo Ilagan versus Comelec, Henry Lucky and Gualberto Silva. The court dismissed the petition for certiorari challenging Comelec's resolutions canceling petitioner Ilagan's certificate of candidacy for mayor of Mataas na Kahoy, Batangas on the ground of material representation. Petitioner Ilagan had filed his certificate of candidacy in October 2015 for mayor. This was then opposed by the then Vice Mayor, Mr. Lucky, who filed a petition to cancel Ilagan's certificate of candidacy on the ground of material misrepresentation of his eligibility because Ilagan was then a fugitive from justice. Ilagan had been charged with rape in violation of the law against human trafficking, RA 9208, has evaded arrest and remains at large. The Comelec 2nd Division cancelled Ilagan's COC. The Comelec and Bank did affirm the Comelec 2nd Division's decision. Ilagan's proclamation as mayor was annulled, and respondent Silva, who had then intervened as party, was proclaimed as mayor. Petitioner sought recourse to the court on the ground that the Comelec committed grave abuse of discretion in cancelling his certificate of candidacy and proclaiming Silva, on the ground that he, Ilagan, did not materially misrepresent as he was not a fugitive from justice. The court did not agree with Mr. Ilagan and dismissed his petition. Last item, it's an administrative case involving a judge. In the matter of RTJ-14-2369, the Department of Justice, represented by Secretary Laila M. De Lima versus Honorable Rolando G. Mislang, presiding judge, Branch 167, Pasig City Regional Trial Court, and RTJ-14-2372, Home Development Mutual Fund, HDMF versus Judge Rolando G. Mislang, presiding judge, Branch 167, Pasig City Regional Trial Court. The court rendered the following judgment. Wherefore, premises considered, the court finds Judge Rolando G. Mislang, Regional Trial Court, Pasig City, Branch 167, guilty of gross ignorance of the law in AM numbers RTJ-14-2369 and RTJ-14-2372, and orders his dismissal from service with forfeiture of retirement benefits, except leave credits, and with prejudice to his employment in any branch or instrumentality of the government, including government-owned and controlled corporations. This proceeding emanated from an investigation of a certain Mr. Delphine Lee, who had filed a petition before the then Judge Mislang's court, seeking for a TRO and an injunction. The court, upon investigation, because of the complaint filed by the HDMF and the Department of Justice, adopted the recommendation of the Office of the Court Administrator The Office of the Court Administrator recommended in both complaints that Judge Ms. Lang be found guilty of gross ignorance of the law and dismissed from service with forfeiture of retirement benefits except leave credits. The court adopted this recommendation, finding that the judge had issued 2 TROs, a writ of preliminary injunction and a status quo order, both of which did not satisfy the legal requisites for their issuance, in gross violation of clearly established laws and procedures, which every judge has the duty and obligations to be familiar with. The court also noticed that he failed to properly apply the principles and rules on 3 points in relation to the cases before him. First, the prematurity of the petition. Second, the inapplicability of the so-called prejudicial question. And third, the lack of jurisdiction of the court. His persistent disregard of well-known elementary rules in favor of Mr. Lee clearly reflects his bad faith and partiality. The court also noted that this is not the first time that the judge had committed a serious infraction. There are 3 who did not participate in this case: Justice Velasco, Justice Bersamin, and Justice Hardeleza. That's all I have. Questions? Wala. Going once, twice. Okay, thank you.